Welcome to Your Rights in Your Time. My name is Matthew Johnson, and I'm an attorney in Eugene, Oregon. I practiced law in the area of tenant landlord law for more than 30 years. I'm going to be talking about your rights and obligations as a tenant in a manufactured home or marina facility in Oregon. This presentation is part of a series of short videos discussing various areas of tenant rights in Oregon. These are brief presentations that don't necessarily cover everything or all situations concerning the specific topic of the presentation. So just keep that in mind. This is a general discussion of Oregon law for informational purposes only. It is not intended to be legal advice. It is not intended to apply to your or any specific situation. If you have an individual issue with your landlord, please consult with your own attorney or contact the local legal aid office. They may be able to help you. Today, I'm going to talk about mediation. Now, mediation can be a great tool for resolving minor disputes like noisy neighbors, scheduling conflict with the community events, maybe use of the recreational facilities, etc. It can be used to foster cooperation and a professional relationship between you and your landlord. But it can also be used as a tool for bullying, intimidation, and getting tenants to agree to things that they do not have to and should not agree to. So be wary. Keep in mind that even if you believe your landlord and or manager is acting honestly and in good faith, they are in the business of separating you from your money. And that is their major motivation for everything they do. So don't forget that. And even though the specifics of what you might reveal in mediation are confidential, it can and may be used against you in the future. So keep that in mind when you're in mediation. Mediation is not good for things involving your rights as a tenant under the Oregon tenant landlord law. Keep that in mind. Here are some advice and strategies that have been shown to be effective to protect a tenant if you are involved in mediation with your landlord. And I'll start with mediation initiated by the landlord. I have 18 recommendations. Number one, the mediator is not your friend. They are supposed to remain neutral. So be very suspicious when they say they're on your side. It's not their job. Okay. Number two, the mediator will not decide anything, and you do not have to agree to anything. Mediation does not need to result in any agreement at all. Mediation is a conversation that does not require a resolution. There are no winners in mediation, so don't try to win. Three, and this is probably the most important piece of advice you'll get here. Insist that the parties remain at all times in separate rooms. Never let the landlord, and especially their attorney, talk directly to you, the tenant. Make the mediator shuttle between the two of you. This is very important. Make this very clear to the mediator ahead of time. It is not an unusual practice. Mediators understand and are very familiar with shuttling between the two parties, and they should be absolutely comfortable doing this. You can and must insist on this. It's extremely important to maintain that separation. And again, this may be the most important thing I tell you here. Okay, so 4, insist that if they, the landlord, initiated the mediation, that they must state clearly what it is they want to mediate before the mediation begins, and preferably before you even agree to mediation. The landlord may insist or ask the mediator to ask you that the tenant give the reason for the mediation after they, the landlord, have initiated it. Don't fall for that. If that situation happens, or if the mediator says to you, well, tell us why you want to mediate, your response is, they initiated it, not me. So it's up to them to let everyone know what it is they want to mediate. And then make sure everyone sticks to just the subjects they have listed and nothing else. Number 5, tell the mediator that if the landlord threatens you in any way, it is inappropriate and may be necessary to end the mediation that if that occurs. Now, make sure the mediator understands that threats often come in the form of a question. I wasn't threatening, I was just asking a question. Here's how it's done. Does the tenant know that they could lose their home, they could have to go to court, that they could get evicted? That's a threat. It's a very common form of a threat. Oh, well, if you don't agree to what we want, do you know that you could get evicted? Don't allow this, and don't allow the mediator to convey these kinds of threats. Make sure the mediator understands that threats generally come in the form of a question. Number 7, tenants are not obligated to answer any question from the landlord and should generally ignore those questions. Demanding you answer a question is a form of bullying. One response is just to answer with your own question, but really try to avoid getting sucked into just asking questions back and forth. Okay, so number 8, do not argue with the mediator and don't allow that mediator to argue with you. Again, it's just a conversation. Number 9, do not allow the landlord to pick their own mediator. And they will try to do this. They will offer to pay for it. You've already paid for it in your rent. So you must insist that they use a mediator from the local CDRC, Community Dispute and Resolution Center. These are people who are trained mediators. They're not litigators. And that is better for you as a tenant. And an aside here, no matter how strong your legal argument might be, mediation is not litigation. And it's not the time to reveal your legal arguments, strategy, or evidence. Keep that to yourself. Often landlord attorneys don't want to mediate. They want to litigate, and they want to use the mediation to litigate, especially with folks who are not experienced or prepared for litigation. And where the usual rules in litigation, rules that keep landlords in check, do not apply. So don't engage in legal arguments. It's not appropriate in mediation. And don't allow them to try and overwhelm you with their legal arguments. It's mediation. It's not litigation. Okay. So, number 10, landlord attorneys will try hard to use mediation for pretrial discovery as well. This is, again, not the purpose of mediation. So don't reveal your arguments, evidence, or strategy. Save it for court if necessary. Tenant's position should generally be the landlord just needs to obey the law. This is what the tenant should be talking about. How can I get the landlord to follow the law? Not what the law is. Well, you need to just ignore the landlord's legalistic arguments. It's another form of bullying. And this is mediation, not litigation. 13, while it might be helpful to reveal the tenant's argument, strategy, evidence to the mediator, make sure that the mediator knows this is confidential information you're giving the mediator and that they keep it confidential. Mediation is not the time to reveal this information to your landlord. You, the tenant, are not trying to win here. You're just trying to reach some kind of mutual agreement through a conversation. 14. Again, mediation is not arbitration or litigation. This is not a case to be heard and or decided by the mediator. If you hear your landlord or their attorney using those terms, it is clear that they are not there to mediate. They are there to try and intimidate you. So act accordingly. Mediation, again, is a conversation, and it doesn't require any resolution. If there's a legal answer or solution, mediation is probably not appropriate. Okay, so 15, if at some point you are feeling intimidated, overwhelmed, it is okay to stop the mediation. You can always pick it up at another time. 16, it's okay and it's not unusual to walk away from mediation without any agreement at all. Keep that in mind. 17, a tenant does not have to agree to anything at all. 18, tenant does not have to compromise on anything or give up any rights. You have rights and you should make sure that you hang on to them. Those are my advice, recommendations if it's a landlord initiated mediation. Now, I have a few more if it is you, the tenant, who has initiated it. We'll start with number 1, and that is try and implement all those other recommendations I've already given about a landlord initiated mediation. If you have initiated the mediation, you set the agenda. Make sure the focus and discussion remains with your agenda. Stick to your agenda and don't let the mediator or the landlord hijack your agenda or the mediation. If the landlord wants to mediate something else, they can initiate mediation on their own. So stick to what you're there for. Stay away from legal arguments or justification. Just insist that the landlord obey the law. There should be no argument about that, right? Without arguing what the law is or what it requires for them to do. So if absolutely necessary, state what you believe the law is or what they are required to do, and insist that that's not up for debate. That is your starting position. Law says this, the landlord must do this. I'm not going to argue about that. That's where we're starting from. But it's really best to try to avoid talking about the law, because they or their attorney will try to talk circles around you and the mediator, and that doesn't get you anywhere. Number 5, again, you don't have to agree to anything. Number 6, you don't have to compromise on anything. Number 7, it's okay and not unusual to walk away without any agreement. I can't tell you how many mediations I've participated in where we just couldn't agree on anything. So end of the mediation. If your landlord has an attorney, you really should have one as well. And make sure your attorney is familiar with all of these caveats and follows them. Mediation can seem cooperative or friendly, but don't let your guard down. If the discussion seems to be going off someplace that you are not comfortable with, end it. You can end it. That's your power. Finally, I think it's a good idea to give the mediator a copy of these suggestions so they understand your concerns. And when you give them a copy of these, you should also instruct the mediator that this is confidential information and they need to keep it to themselves. I will make these guidelines available in written form with this video. So I think this covers the essentials here. Good luck.